where you see the passing of time.
The crowds in St. Peter's Square are praying like mad for the Pope's life.
Where moments refuse to die.
This is a momentous hour in world history. This is the invasion of Hitler's Europe.
And where victory lives on.
Plenty of girls are being kissed by plenty of boys they don't know, and they do not care.
You can love it, hate it, embrace it, or turn away.
Lennon was shot to death late last night outside his apartment building.
But it is a past we all share.
Come on out here and give me a salute. Big Navy salute.
This is where yesterday has a home, where we wonder what it was like back then.
Go forward, knights, in safety.
And not too long ago.
His spirit must live on.
It's where history has its place and where the past comes alive. The History Channel.
Anything that I might do in 1981 would be solely for Jodie Foster's sake, and I mean that sincerely.
In John Hinckley's world, and this was an act of heroism to prove to Jodie Foster that he was dedicated to her. Rather absurd, bizarre thinking, don't you think?
She's an animal. She put a 38 to my kid's head. I have no pity on her. I have no pity on the psychiatrist that let her loose.
The insanity defense is not something that psychiatry created or the mental health community created. It's something that the law created.
David felt he was sane. I mean, it's the old thing about what kind of insane person is going to say, yes, I'm insane.
President Ronald Reagan had been in office just 2 months. It was March 30th, 1981. At 2:25 p.m., after a speech at the Washington, D.C. Hilton, he was leaving the hotel. A young man with a gun was pushed to the pavement. Secret Service agents shoved the president into a car. They sped away. The would-be assassin had shot a policeman, Thomas Delahanty, Secret Service agent Tim McCarthy, and White House Press Secretary James Brady. A bullet hit Brady in the forehead and ripped through his brain. Bystanders rushed to help. In the president's car, it was not clear at first if Reagan had been shot, so the car headed for the White House. But Reagan was short of breath and began coughing up blood. The car now switched course and raced toward George Washington University Hospital. A bullet had pierced his left lung. It was lodged 3 inches from his heart. 2 hours of surgery were needed to remove it. In the White House press room, Secretary of State Alexander Haig made a frenzied announcement.
As of now, I am in control here in the White House, pending return of the Vice President and in close touch.
Back outside the Hilton, the gunman had been arrested. He was 25-year-old John Hinckley Jr., son of a wealthy oil executive. It would soon emerge that the young man had a long history of mental instability. His trial would become a pivotal moment in American justice, a nationwide reflection on what it means to plead insane. Would someone who nearly killed the President of the United States avoid punishment if a jury decided he was out of his mind? Or would vengeance be exacted against the would-be assassin, insane or not? The long trail leading to the assassination attempt began, of all places, in Dallas, where John Hinckley Jr. grew up. As a teenager, he dreamt of becoming famous as a guitarist in a rock and roll band, but he never took music lessons. He was an average student who spent most of his free time alone in his room. After high school, he attended Texas Tech University on and off for 7 years without graduating. During college, Hinckley began to admire Adolf Hitler. He wrote a book report about Hitler's manifesto, Mein Kampf, he became fascinated with a neo-Nazi group based in Nebraska. Lee Harvey Oswald was also his personal idol. He photographed himself holding a rifle, trying to imitate a well-known picture of Oswald taken several months before the assassination of President John F. Kennedy. The idea of killing a political leader grew stronger in Hinckley's mind beginning in 1976. While visiting Hollywood for several months, he went to see the hit movie Taxi Driver. Over the next 5 years, he would watch the film 15 times. Hinckley identified with the lead character, Travis Bickle, played by Robert De Niro. In the movie, De Niro stalks a man running for president. Hinckley posed with weapons the way Bickle did. Imitating a scene from the movie, he photographed himself with a pistol pointed at his head. The De Niro character also saves a young prostitute, played by Jodie Foster. Over the next several years, Hinckley became obsessed with the actress. In 1980, he read that she was attending Yale University. He decided he needed to meet her somehow, so he invented a story, telling his parents he had enrolled in a writing class at Yale. Hinckley traveled to the Yale campus in New Haven, Connecticut, where he tried to contact Foster. He called and wrote letters. He succeeded in talking with her on a few occasions. Foster made it clear she wanted nothing to do with this apparently crazed fan, but Hinckley believed he could still win her affection if he assassinated the President of the United States. Hinckley left Yale in late September 1980 and flew to Lubbock, Texas, where he bought two .22 caliber handguns. The trip was his first in a series of cross-country treks leading up to the violent act, which Hinckley fantasized would finally win him love and his most treasured goal, fame. He decided to stalk President Jimmy Carter, who was then campaigning for re-election.
Are we gonna win?
Over a 3-day period from September 30th to October 2nd, Hinckley followed the president from Washington, D.C. to Columbus and Dayton, Ohio. On the third day, he attended this Carter campaign appearance, and as this video shows, was standing just a few feet from the president. But he had lost his nerve and had left his weapons back in the hotel room. Over the next 18 days, Hinckley traveled between cities where Carter was making campaign stops and New Haven, where he left more notes and letters for Jodie Foster, none of which said he was planning to kill the president. Hinckley was running low on money. So in mid-October, he went to see his parents, who now lived in Evergreen, Colorado, just outside Denver. After taking an overdose of medication, he began to see a psychiatrist, John Hopper, for depression. In December, Hinckley was distraught to learn about the murder of one of his music idols, John Lennon. He joined the many thousands of fans in New York who mourned Lennon's death. On Valentine's Day, 1981, Hinckley contemplated killing himself in the same spot where Lennon was slain. He went to the site, but again lost his nerve and was unable to pull out the gun he had brought with him. Hinckley returned to Colorado in late February. He had his last appointment with Dr. Hopper. Hinckley told the psychiatrist nothing about his travels or his plans. Once more, he flew east, leaving more notes and poems for Jodie Foster in New Haven. When he ran out of money, he begged his parents to let him come home again. Jack and Joanne Hinckley had no idea what their youngest son had been up to. They felt the main problem was that he lacked direction and initiative. So they followed the advice of Dr. Hopper. John was allowed to return home, but when he did, his father gave him some money and told him he should now make it on his own. Days later, John told his mother he hoped to make it in the music business and had decided to go to Hollywood again, to give it one more try. Mrs. Hinckley drove her son to the Denver airport on March 25th. John flew to Hollywood but stayed only a day. He boarded a bus to Washington, D.C. Hinckley arrived March 29th. The next morning, he checked the paper for President Reagan's itinerary. He wrote one last note to Jodie Foster describing his plan to, quote, get Reagan, and expressing fear he would be killed in the attempt. He hoped she would admire him for, in his words, this historical deed. He left the note in his hotel room. Then he loaded his .22 caliber. Of the 37 bullets in his possession, he chose 6, which would explode on impact.
It's natural enough to think that anyone who takes a gun and tries to kill the President of the United States is out of their mind. But was John Hinckley Jr. insane when he shot President Reagan? And if he was insane, should he be punished? Before deciding whether someone is guilty, American justice takes into account the defendant's state of mind. Hinckley's attorney would argue, in a classic use of the insanity plea, that his client did not appreciate that what he was doing was wrong, that he had, so to speak, lost his moral compass. On that basis, he entered a plea of not guilty by reason of insanity. The evidence: Hinckley's years of isolation, his frenetic activity in the months leading up to the assassination attempt, and his obsession with Jodie Foster. It would all come into play during a trial that would force American justice to reconsider the meaning of pleading insane.
Soon after John Hinckley Jr. was arrested and charged with attempting to assassinate President Reagan, it became clear that pleading insane would be his best defense. There was no question that he was the gunman. In the end, however, it was not just Hinckley who went on trial, but the insanity plea itself. On the day of the shooting, Hinckley's parents hired well-known Washington attorney Vincent Fuller to represent their son. Hinckley was jailed in an isolated cell at the U.S. Marine Base in Quantico, Virginia. Fuller interviewed him there the next day.
I went down to Quantico to see him the day after the shooting, the 31st of March. And you knew he was out of touch. I remember asking him, "Do you have a girlfriend?" And his response was, "Well, kind of, sort of, yes, but it's a one-way relationship." This turns out to be Jodie Foster.
At Yale University, Foster told reporters that she had known nothing about Hinckley's plans to kill the president.
In none of these letters and notes I received was any mention, reference, or implication ever made as to violent acts against anyone, nor was the president ever mentioned.
Hinckley's obsession with the actress would be the key to his defense. Fuller immediately picked up what he regarded as evidence of mental disturbance.
Anybody who spent 5 minutes with John Hinckley knew he was not the all-American boy. He was depressed. He was very difficult to communicate with. As an example, to get eye contact was almost impossible.
Hinckley tried to commit suicide in jail by hanging himself with a jacket. Fuller hired several psychiatrists, including Dr. William Carpenter of the University of Maryland, to examine him.
He thought this young man had been suffering from schizophrenia for a period of 15 or more years before the shooting, that it took that much time for the disease to progress to the point that it just totally disturbed his ability to think, reason.
Pleading insane is no simple matter. It's a strange branch of American justice where law and psychology get easily tangled, where one expert might see a highly disturbed individual, another perceives a basically rational person. There are other dangers as well.
One of the considerations was whether presentation of the insanity defense would perhaps do him more harm than good, because to present the defense properly, you really have to trace his entire life as best you can reconstruct it, and it was not a pretty picture.
At first, Hinckley did not even want to plead insane.
To Hinckley himself, he was guilty. He begged to be convicted and sentenced to 15 years to life. He wanted to plead guilty. The prosecutor didn't accept that. In fact, Hinckley then said, "All right, sentence me to life imprisonment."
We were insistent that if he pled guilty, that he be sent to an institution that could take care of mentally ill people. And I remember making a presentation to the Department of Justice, to then Deputy Attorney General Rudy Giuliani. Giuliani abruptly said that the government doesn't deal with presidential assassins, and he was going to go to trial.
Giuliani was confident the government could convince a jury that Hinckley was sane and guilty. The trial began in Washington, D.C. more than a year after the shooting, on April 27, 1982. In his opening statement, defense attorney Fuller admitted that Hinckley was responsible for the shooting, which had left White House Press Secretary James Brady permanently disabled. But he argued Hinckley was not responsible for what he'd done.
That is to say, he did not appreciate the wrongfulness of his conduct, or was unable to conform his conduct to the requirements of the law, which was the standard of the time. And this was brought about by virtue of a mental disease or defect.
For John Hinckley Jr. or anyone else who pleads insane, the key question in the courtroom is this: On whose shoulders does American justice place the burden of proving that someone is sane or insane? The defense or the prosecution? The rules vary from one state to another. It can mean the difference between guilt or innocence, between a prison term or a stay in a mental hospital. At the time Hinckley went on trial in federal court, the burden of proof was on the prosecution. That meant the government would have to prove beyond a reasonable doubt that Hinckley was absolutely sane at the time he shot the president. The defense would simply have to convince the jury there was reasonable doubt about his sanity. By all accounts, the prosecution had a much tougher job.
Once you've tried to shoot the president, I would say that it's virtually impossible for anyone to prove that they're sane beyond a reasonable doubt.
To no one's surprise, the trial became a titanic battle of psychiatrists. The defense expert said Hinckley was so obsessed with actress Jodie Foster and so disconnected from reality that he actually believed Foster was his girlfriend. Defense attorney Fuller played an audio tape in court, which Hinckley had recorded by himself 3 months before he tried to kill the president.
Anything that I might do in 1981 would be solely for Jodie Foster's sake, and I mean that sincerely. I want to make some kind of statement or something on her behalf. Just tell the world in some way that I worship and idolize her.
He had this obsession about Jodie Foster. That was driving him to do something, and he didn't know what it was to do. But eventually he had thoughts of suicide, of shooting her, shooting himself in front of her, shooting them both. A lot of bizarre thoughts went through his mind.
The lead expert for the prosecution, Dr. Park Dietz, agreed that Hinckley did have some mental disorders, but he did not regard them as serious. He pointed out that Hinckley was sane enough to stop stalking President Carter and begin stalking Ronald Reagan immediately after Election Day in 1980, and that he carefully concealed his stalking from his parents. Other prosecution experts called attention to the ways Hinckley did function normally, such as schoolwork he did in college, his ability to travel nationwide, and actual phone conversations he had with Jodie Foster, which were also taped by Hinckley.
You understand why I can't, carry on these conversations with people I don't know. You understand that it's dangerous and it's just not done. It's not fair and it's rude. Oh, all right?
Well, I'm not doing it.
Well, I understand that.
Prosecutor Roger Edelman painted a picture of Hinckley as a lazy young man who hoped to inherit a great deal of money from his parents and who wanted desperately to become famous in some way. The prosecutor added other examples. Hinckley had the foresight to buy concealable handguns and the calculation to purchase a special kind of bullet that explodes on impact. Fuller countered that Hinckley's intelligence and premeditation did not prove he was sane.
The government argued very strongly that all these things are the acts of a rational person. Well, there are many, many people who suffer from mental disease or the defects are very intelligent people. They're very orderly in what they do. They think rationally. They plan. They plan very skillfully.
Here again, American justice had set up a high hurdle for the prosecution. For the government to put Hinckley behind bars, it would have to prove that he appreciated that what he did was wrong.
If you were to ask him, is it right to shoot presidents, he would have said, no, you shouldn't do that. But he didn't appreciate the fact that that is illegal. He didn't appreciate the fact that to shoot those people was going to hurt them, that he might kill them.
After 8 weeks of testimony, the jury retired to decide the fate of John Hinckley Jr. Judge Barrington Parker reminded the jury that if they had any reasonable doubt that Hinckley might not be sane, they had no alternative but to find him not guilty by reason of insanity. After 4 days of deliberations, the jury did exactly that. The judge ordered Hinckley confined at a hospital for the criminally insane, St. Elizabeth's.
The best evidence that Hinckley was insane at the time he committed the crime is when he gets to St. Elizabeth's Hospital and makes continual threats on Jodie Foster's life. There's a man who doesn't understand the consequence of his actions.
President Reagan sought to avoid this subject.
You think justice was done, sir?
No comment.
But the Hinckley verdict was instantly unpopular with the public and with lawmakers.
We sort of turn the whole thing upside down when we require
the prosecutor to prove that a person was sane instead of the defendant to prove that he was insane.
There was a lot of outrage in the popular press and in the media, and one of the things that happened was that many state legislators rushed to introduce new legislative reform to avoid the perceived abuse that John Hinckley seemed to represent to much of the American public.
In all, the Hinckley verdict inspired 39 states to make it harder in various ways to plead insane. The U.S. Congress did the same for federal insanity law, shifting the burden of proof from prosecution to defense. As for John Hinckley Jr., he is to remain confined at St. Elizabeth's Hospital for as long as the authorities regard him as a possible threat. His fate, like that of anyone who is found insane, is in the hands of American justice, perhaps for the rest of his life. So even though the government lost the Hinckley case, it has as much control over him as if he had been sentenced to life in prison.
Now, whether he will get out or not would depend not on his mental condition and not on what the psychiatrists indicate as improvement. It would depend on the Secret Service, the Department of Justice, the FBI, and the courts. They will decide whether John Hinckley ever leaves the hospital.
Hinckley's defense was successful. It was also very expensive. The estimated cost, more than $3 million. Hinckley's well-to-do family could afford to pay the bills for those high-priced defense witnesses to testify that he was literally out of his mind. It's an example of why pleading insane is known as a rich man's defense. But the insanity plea is hardly some kind of modern-day legal loophole. It took shape back in 19th century England after a Scotsman tried to kill a prime minister, but instead shot and killed his private secretary.
When John Hinckley Jr. was found not guilty by reason of insanity for the attempted assassination of President Reagan, the outcome sparked more than just efforts to tinker with the law. It made people reconsider the very meaning of pleading insane.
The insanity defense is not something that psychiatry created or the mental health community created. It's something that the law created.
And created for a reason deeply rooted in American justice, the idea that society should never punish someone who is not mentally responsible.
By being responsible, it meant that they had the ability to exercise free will to either choose to do something bad or to choose not to do it. And if, in fact, because of their mental state, they did not have the ability to form the intent, then we could not punish them.
A noble idea. But in the practice of American justice and under the relentless glare of the media, the actual question of a defendant's sanity is often obscured by public thirst for vengeance, either against an assassin or an obviously crazed killer. The so-called son of Sam, whose real name was David Berkowitz, was arrested in New York City in August 1977 after a string of brutal murders that terrorized the area and for months were fodder for the tabloids and TV news. Berkowitz told authorities that his neighbor Sam Carr was sending him demonic messages through his dog, ordering Berkowitz to kill. Even after his arrest, Berkowitz insisted he was still acting on orders from Sam and Sam's dog.
From the outset, one knew this man was not sane.
Much too insane, according to his lawyers, even to stand trial. And so insane that the best thing American justice could do with him was lock him up for the rest of his life in a hospital where he could be examined for the benefit of science.
Here we had somebody alive. We could study them, see the operation of the mind, find out what turns that type of a person's violence from the inside out.
But prosecutors did not share the defense attorney's interest in scientific enlightenment about serial killers. They wanted vengeance. And so, despite considerable expert testimony that Berkowitz did not even understand the charges against him, he was found competent to stand trial. At which point Berkowitz, on his own, against the advice of his lawyers, entered a simple plea of guilty. He wanted to prove to the world that the voices he heard were real.
That was our greatest fear, because he would not, David himself would not let us assert an insanity defense. He denied he was insane. David felt he was sane. I mean, it's the old thing about what kind of insane person is going to say, yes, I'm insane.
Berkowitz was immediately sentenced to 365 years in state prison, where he receives no psychiatric counseling.
It was always, to me, a blatant shame that he was treated as a criminal rather than an insane person. He had about as much responsibility for his actions as a lion that escaped from a cage in the circus.
But in that sense, the outcome of the Son of Sam story was not that unusual.
You must understand that most mentally ill people who commit crimes, mentally ill offenders, are convicted of their crimes and go to prison. Thus, we have in the prisons a large number of people who need psychiatric treatment.
But if American justice has not yet figured out how to deal properly with disturbed criminals, it's not for lack of time to think about it. In fact, over the last 200 years, public outrage over cases very much like those of David Berkowitz or John Hinckley Jr. has repeatedly forced lawmakers to define and redefine insanity. And like so much of American law, it all goes back to the mother country, Great Britain, and to other attempted assassinations.
In 1800, Edward Hatfield tried to kill King George III. As King George entered the Drury Lane Theatre in London and was about to bow to the audience, Hatfield fired a shot that just grazed the top of his head.
Hatfield pleaded insanity and was acquitted. What bothered the British Parliament was not so much the acquittal. It was that the judge had no clear authority to keep Hatfield in any kind of custody. So the British passed a law that attached a new state power to the verdict of not guilty by reason of insanity.
In other words, up until 1800, if you were found not guilty by reason of insanity, you were allowed to go home. The court had no power over you. Now, insanity became a special verdict, a not guilty by reason of insanity, and was tied to automatic confinement in a jail or mental hospital.
But even after Hatfield, there was no clear definition of insanity itself. It would take another attempted assassination 43 years later to accomplish that feat.
On January 21st, 1843, a young Scotsman by the name of Daniel McNaughton tried to shoot Sir Robert Peel, the Prime Minister. But he shot Sir Robert Peel's private secretary, Edward Drummond, by mistake.
McNaughton pleaded insanity. He won and was sent off to London's Bethlehem Hospital for Lunatics, otherwise known as Bedlam, for the rest of his life. The public was incensed.
The outrage led to the court asking the Lords, which were the Supreme Court of England, really, to go ahead and make a ruling on the insanity defense. And what they did is that they came up with the ruling, which was known as the McNaughton rules, which was essentially the right from wrong test of criminal insanity. And to say that if a person knew the difference between right and wrong, then he was responsible for his behavior.
The McNaughton rule soon became the standard on both sides of the Atlantic. However, back in Washington, D.C., a story worthy of the tabloids was soon forcing American justice to consider a different problem. What did it mean to plead temporarily insane? New York Congressman Daniel Sickles was upset that his young wife was having an affair with Philip Barton Key, son of the famous Francis Scott Key, author of the Star-Spangled Banner. On February 17, 1859, Sickles tracked down Key just steps from the White House. He shot him fatally. Sickles was charged with murder. His lawyers did not try to argue that he was totally insane, only that his mind was affected by his wife's affair, and there had not been sufficient time for his passion to cool. He was temporarily insane. The jury agreed. Sickles was acquitted.
What he tried to do is expand the insanity defense to include this momentary lapse of reason, because what he was essentially arguing was that the man deserved to die for what he did. He quoted the Bible. In fact, up until 20 years ago or so, Texas had a law that if a man discovered his wife in bed with another man, then he had the right to kill her.
No such luck for another Washington killer and supposed madman, whose case proved an important lesson about pleading insane. On July 2nd, 1881, a disgruntled office seeker named Charles Guiteau shot and mortally wounded President James Garfield. Guiteau said he was convinced that God had ordered him to shoot Garfield for the betterment of the country. He too pleaded insane, but the jury found him guilty, and Guiteau was hanged. So there was little sympathy for Guiteau's insanity plea, for a reason that has everything to do with American justice and nothing at all to do with psychology. Quite simply, Guiteau succeeded in killing the President of the United States.
If the person who is the target of the assassination dies, then the desire to punish overwhelms, and the person is found guilty. If the person doesn't die, then usually they're granted the verdict of not guilty by reason of insanity. If Reagan died, Hinckley would have been found guilty.
In the 140 years between Daniel McNaughton and John Hinckley Jr., politicians have refined the test for insanity in various ways, beyond simply telling right from wrong. But juries are not known for spending much time on such nuances. They just use their common sense.
Once a case gets to the jury, the research shows that it doesn't really make a difference what rule you use, what test of insanity you use. The jury is basically asking the question, is this guy so crazy, and is his crime such that we want to relieve him of criminal responsibility? That's the question that they're asking.
Few people who plead insane to violent crimes are ever found not guilty, but even when someone is acquitted, the next step is usually a long period confined to a mental hospital, often for more time than a prison sentence would have been. But there is still the fear that some defendants will fake insanity to avoid punishment. And if someone really is insane, will American justice see to it that the criminal is kept from being a danger to others in the future?
The fear that someone might get away with murder by faking insanity surfaced in the famous case of the California Hillside Stranglers. In 1977 and 78, the bodies of 10 women were discovered around Los Angeles. Most had been raped and tortured before they were strangled to death. After a year-long manhunt, 2 cousins, Angelo Buono and Kenneth Bianchi, were charged with the crimes.
They loved killing. They loved power over women. They loved torturing women.
Kenneth Bianchi, arrested in Bellingham, Washington after 2 more murders, told police he was innocent. He agreed to undergo hypnosis and seemed to reveal a second personality, a foul-mouthed bully named Steve. Steve confessed that he was the real killer, rebelling against his alter ego.
I f***ing killed those broads, you know, to smarten him up, to show him that he couldn't push me f***ing around.
If Bianchi was really suffering from the rare condition known as multiple personality disorder, he could be ruled insane. But he was soon unmasked as a faker when, supposedly under hypnosis again, Bianchi reached out to shake hands with a lawyer who he said he thought was in the room. But genuine hypnotized subjects never touch their hallucinations.
Well, if he was faking the hypnosis, then it more or less follows that what underlay that, the multiple personality, was phony as well.
Bianchi and his partner in crime, Angelo Buono, were both eventually found guilty of murder and sentenced to life in prison. When someone commits a horrible crime and is found not guilty by reason of insanity, the victims of that crime expect at the very least that the offender will spend a long time locked up in a mental hospital. But American justice can work in mysterious ways. The phone rang in the middle of the night in the Indiana home of Donald Martin.
I got on the phone, and whoever I talked to said, I'm sorry, but your wife shot your kids. And I just threw the phone down, and I fell to my knees.
The previous day, September 19th, 1992, Martin's estranged wife, Kimberly, had packed their 2 children, 8-year-old Dusty and 4-year-old Brandy, into her car and driven west from South Bend, Indiana. She crossed Illinois and most of Iowa. Late that evening, an Iowa state trooper pulled her over for failing to pay for gasoline at a truck stop.
The trooper saw the children in the back and thought they were asleep, and he asked if the children were okay, and she basically said they're dead.
Both children had been shot in the head with a .38 caliber pistol. Martin was brought before an Iowa judge and charged with the murder of her children. But as the judge was reading the charge, she interrupted him in a weak, eerie voice.
I'm sorry.
The 29-year-old Martin told psychiatrists she was 14 years old, and yet she still called herself by her married name. She seemed to have lost all memory of the latter half of her life, including the murder of her children. The judge ruled Martin was not competent to stand trial and sent her off to a mental hospital. The public defenders assigned to the case were convinced Martin was insane.
To fake that type of symptomology would require an Academy Award-winning performance with plenty of rehearsal.
At first, Iowa prosecutor Rick Crowell was skeptical.
I thought this is all a made-up story. And I was working off of different theories of why would she shoot her children? Well, they're going through a divorce. Maybe she wants to get back at her husband.
But Martin was giving a very different story to the psychiatrists. Like the son of Sam, Kimberly Martin said she was hearing voices.
The voices were telling me that my children are going to be meeting a horrible death, that the daughter was going to be molested and then crucified, and the son was going to be burned to death, and she was going to be stoned to death.
All the Iowa doctors who examined Martin, including the state psychiatrists, agreed she was suffering from serious mental illness, paranoid psychosis. But after 5 months in the mental hospital, Kim Martin was ruled competent to stand trial, meaning that she could at least understand the charges brought against her. Her lawyers prepared to argue that Martin was insane at the time she murdered her children. And with the unanimous expert testimony that Kimberly was seriously mentally ill, even the prosecutors now believed Martin passed the age-old McNaughton test for insanity.
She didn't know the nature and quality of her act or be able to distinguish right from wrong.
Martin's trial on July 8th, 1993, took all of 8 minutes.
I believe all reports show that at the time these murders occurred, that she was incompetent and was insane and had no criminal intent.
Kimberly Martin was found not guilty by reason of insanity and sent to an undisclosed Iowa facility for further psychiatric evaluation. But just 2 weeks later, she was quietly and mysteriously released, a free woman. Under Iowa law, the facts concerning Martin's release were highly confidential, but the meaning was clear to the public. According to the state of Iowa, Kimberly Martin was no longer insane. The lawyers say her quick recovery was something of a medical mystery, but nonetheless, very real.
Since we don't know why mental illness occurs in the first place, with some good guesses, we don't know what course it will run in any particular diagnosis. Who can say that it can't be alleviated quickly?
Donald Martin, now Kimberly's ex-husband, was outraged.
I feel she's an animal. She put a .38 to my kid's head. I have no pity on her. I have no pity on the psychiatrist that let her loose. Common sense tells you it's not right.
On the contrary, say Kimberly Martin's public defenders, American justice was served.
This case in particular is about the best argument you can make for the insanity defense. As far as we can tell, and all the information that we've gathered, Kim Martin was a good person, a loving mother, and all the mental experts feel that she's treatable, and she has been treated, and they think she's no longer a danger to herself or others.
I'm a secondary victim. My kids are the victim. What happened to their rights? And look at her, she gets to walk free. I have no idea where she's at. I don't want to know where she's at. Because I don't know what my reaction is going to be if I ever see her ever again.
The problem with our law is that if there's a period of time when she's not of danger to herself or others, she's out. That doesn't mean that she, down the road, might not be psychotic.
And while all of the attorneys involved in the Martin case seemed to agree that legally the outcome was correct, not all felt it was fair.
In a case like this, what is legally right and morally right are somewhat in conflict. Anytime you have an insanity defense, the act itself is going to be morally reprehensible. It's going to be a morally wicked act. So if you look at it from a personal standpoint, you're going to want somebody to be punished for that.
I just hope God's got a special place for them because of the way they went.
Many people, when they hear about cases like that of Kimberly Martin, wonder if there should be an insanity defense in the first place. How can a woman be judged so disturbed that she is not responsible for the murder of her own children, and then, just weeks later, be released as a sane person? On the other hand, some crimes are so awful that jurors refuse to accept insanity as an excuse, even when the evidence of mental disturbance is compelling. Such was the case with serial killer Jeffrey Dahmer. Cannibalism and necrophilia are not usually regarded as sane behavior, yet Dahmer was found legally sane.
If ever a criminal seemed on the surface to pass the test for insanity with flying colors, it was Jeffrey Dahmer. Dahmer, arrested in Milwaukee in July 1991, confessed to killing 17 young men. Police found body parts in his refrigerator. Dahmer told authorities he had sex with his dead victims, ate their flesh, even painted their skulls. Could any sane person do this? Dahmer pleaded guilty but insane. His attorney, like John Hinckley Jr.'s, might have tried to convince the jury that his client was unable to appreciate that what he did was wrong. But he rejected that strategy.
It was never a question of whether or not he understood the wrongfulness was kind of, he knew what he was doing was wrong. The question was, was he able to stop it?
Defense attorney Jerry Boyle said his client could not stop it. That Dahmer's urge to have sex with dead bodies was a mental illness, which at a certain point, like a runaway train, ran off with his mind.
As he progressed into this killing spree, that he certainly got crazier and crazier. So basically, I tried to argue that he was crazy, certainly after about the 9th or 10th murder.
The fact is, he was not and is not crazy.
Prosecutor Michael McCann told the jury that, on the contrary, Dahmer was a methodical, self-absorbed killer bent on satisfying his sexual drive at any cost. The jury agreed.
Did the defendant, Jeffrey L. Dahmer, have a mental disease? Answer, no.
Dahmer, sentenced to consecutive life terms, was led off to prison, where, like the son of Sam, he receives no psychiatric counseling. As a case of pleading insane, the lesson of the Dahmer trial was clear. In determining sanity, it is the mind of the criminal that matters most, not so much the things he does. Jeffrey Dahmer, David Berkowitz, the Hillside Stranglers, these men will certainly never be released from prison, but by focusing on these sensational insanity cases, we often ignore a much greater and more pressing danger.
If the public is fearful, they ought to be more fearful today when mentally ill criminals are found guilty, are sent to prisons, and then have to be released at the expiration of their sentence, and they're still mentally ill and dangerous.
While those criminals return to the streets, critics charge, there is another cruel irony. When people are acquitted on grounds of insanity, many of them are held in mental hospitals much longer than necessary, either because they were faking insanity or were not seriously ill in the first place.
There are over 5,000 people who are being housed at this very moment in hospitals for the criminally insane throughout the country, diverting the treatment services of a large number of mental health professionals from what they should be doing, because at least 30%, some will say more than that, of people who are housed in these maximum security hospitals are not mentally ill.
The answer, says New York psychiatrist and insanity plea expert Abraham Halpern, is to abolish the insanity defense and close hospitals for the criminally insane. Instead, just find defendants guilty or not guilty. If they're convicted, then let judges mete out punishment or treatment based on how dangerous, how sick, and how treatable each offender is judged to be.
If they are dangerous and mentally disordered, they could then go into confinement in a regular prison system where there will be mental health professionals who can treat them if they need treatment or if they're treatable. Those who are not dangerous can go on probation, especially if they're treatable.
Some states, including Montana, Idaho, and Utah, have in fact abolished the insanity defense, arguing that it undermines the reputation of American justice. Those who defend the insanity plea admit it can be abused.
Certainly people who are sane sometimes argue that they're insane. But you know, people who are guilty argue that they're not guilty. And nobody seems to, think that we should get rid of the not guilty verdict as a result.
In March 1994, however, the United States Supreme Court backed up the decisions of those states which have abolished the insanity defense and let stand laws which deny people the right to plead insane.
Should American justice do away with the insanity defense? Those who say the answer is yes point to stories like this one. A man in New York City, a Vietnam veteran, had committed a string of burglaries. He pleaded insanity, claiming he was suffering post-traumatic stress disorder from the war. 7 psychiatrists agreed he was insane. He was acquitted, confined to a mental hospital. Then he appealed for release, claimed he was not insane, and in fact had never served in Vietnam, but at a base in Texas. But the court told the man, too bad. Since you lied your way out of a prison term, you have to stay in the hospital. Such cases, say opponents of the insanity defense, make a mockery of both mental hospitals and American justice.